In every matter, an attorney makes a countless number of choices, some tactical and some inconsequential, some immediate and some prospective, some deliberate and well-informed, and some hasty and ill-informed. Together, the combination of choices drive the matter towards resolution. Counsel for defendant chose to let the jury trial proceed without their participation or court reporter. Unfortunately for the defendant, these and other choices led to a multi-million-dollar verdict. Different choices might have led to a different result. In cases like these, we do not serve as a safety net for bad choices. Or as we said in the Marines, but with far less eloquence, play stupid games, win stupid prizes. Today's opinion is about a multi-million-dollar case that broke bad, really. On the eve of trial, defense counsel files a continuance request, pleading that the defendant had to fly out to Florida for a family emergency and couldn't be at trial, but there was just one problem. He lied about leaving. He was in fact sitting in Illinois doing... the trial attorney likewise indicated that a family member of hers was ill, but to be fair, there's nothing in the opinion suggesting the lawyer was dishonest in that assertion. She also claimed she was unprepared for trial because 2 witnesses apparently were no longer available. After a short wild goose chase where the defense counsel was kind of running from courtroom to courtroom looking for the right judge to present the motion to, the trial judge denies the continuance because, per Cook County administrative order, the length of delay sought was in excess of the judge's authority, so that the attorney has to bring the issue to the chief judge of the law division for approval. However, the trial judge was a bit sympathetic to counsel's situation, and not knowing yet about the client's dishonesty, he kicks the case over for a day to allow the attorney to present her motion to the chief judge. But the motion was never presented. The trial moves forward, but without the defendant present and his 2 attorneys, I guess they both stood outside in the hallway looking in through the window while the jury was handing down a multi-million-dollar judgment in their absence. So they then file a motion to vacate, and for the first time, they admit that their client lied on the continuance affidavit regarding the reasons he couldn't attend. It's inferred from the opinion that when the judge heard this and expressed significant displeasure from the bench before denying the motion, the defense appeals and the appellate court affirms. In regards to comments from the bench, if a judge's comments derive from an extrajudicial source, it might show bias. Extrajudicial would be something that sort of happens outside of the courthouse. But, if the comments are in response to a party's conduct or misconduct, that's fair game. In addition, the judge's comments here were post-judgment, so ipso facto, they had no bearing on the actual jury trial. Again, the defendant had the chutzpah, and I'm not Jewish, I just like the word, the chutzpah to lie to the judge, and then after who knows how much money was spent by the other party dealing with that lie, comes back to the judge and the other attorney and says, "Oh, my bad." Although notwithstanding the defendant's lie, counsel for defendant, as you may recall, also had her own family emergency, but that had no bearing on her co-counsel, who likewise elected to sit the trial out. Turning to the court's decision to proceed with the ex parte trial, case law is pretty clear here. If a party or attorney could have participated but elected not to, that's not a valid basis to vacate. And lastly, the appellate court quickly addresses the lack of a court report. Basically there's no mandate or rule that one has to be present in this type of case. In short, the appellate court sort of calls it like it is by stating this. Considering the total lack of diligence by defendant and his counsel, the judge acted well within his discretion. All alleged errors involved choices made by counsel and the defendant. Counsel refused to participate in jury selection or trial or take steps to properly present the motion for continuance to the presiding judge. Defendant filed an untruthful affidavit. And together, this appears more like a tactic to secure a continuance than a series of unfortunate events. Now, I don't have any insight on what really happened, just what's in the opinion. Maybe the case ran off the rails at the 11th hour and maybe people panicked. I don't know. Last minute problems happen in every trial and it's a source of immeasurable stress. Sometimes this stress causes people to do the wrong thing for what they think are the right reasons, but who knows what happened here. Anyways, that's all I have. Thanks for watching.